Good morning, everyone. I wish you a wonderful morning. I'm very much looking forward to the next minutes because this is one of the occasions where I'm very, very optimistic that I will learn a lot from the input. We are going to have 4 people to talk about the most recent activities of the European Commission in the field of AI regulation. In particular, as certainly many of you know, there is a new proposal for a regulation laying down harmonized rules on artificial intelligence on the table. It was presented by the European Commission several weeks ago. It's the last piece of a long list of documents coming from the European Commission since the last years or so, many of them dealing obviously with questions of how to regulate and how to control and at the same time foster the development of artificial intelligence in Europe. And I have a panel here with me that is really outstanding. And I need to start with the remark that it's Oscar's, again, main activity why we have this here today, including many of the people who are here. And I'm very grateful to Oscar that he is kindly giving me so much advice in the field. And I may therefore also start by introducing him. So the first speaker here is Oscar Strein, who is, as some of you know, already Austrian, I'm proud to say, but he spent a lot of his academic career in the Netherlands. Currently, he is professor at the Department of Governance and Innovation at the campus. I don't know how you really explain this or pronounce this, Friesland, where he's a member of the Data Research Center. He studied law and philosophy in Innsbruck, Austria, and he has obtained a Magister Juris and the Magister Philosophia diploma. So he has both a legal and a philosophical background. He is doing a lot of fundamental and advanced and also applied research in many EU projects. That's also one of the reasons why I have been in close contact with him for many years. He is also has a strong background in privacy, security, technology related issues of European law. Inter alia, he was one of the speakers we had in this series and also the mastermind in this case we had in this series when it comes to digital green certificates and green passports and all this, which is COVID-19 related, where he has been very active. And Oscar will open today's agenda. Then the second person to talk to you will be Gloria Gonzalez Fuster. Gloria is a research professor at the Vrije University Brussels, Free University Brussels at the Faculty of Law and Criminology. She is a co-director there of the Law, Science, Technology and Society Research Group, and she investigates legal issues related to privacy, personal data protection, and security, and is teaching in the field, including a course on data policies in the European Union. She has a legal background. She studied law at the Universitat Nacional de Educación a Distancia, and she studied journalism at the Faculty of Communication Sciences in Barcelona. And finally, last not least, modern languages and literatures at the Université Libre de Bruxelles. She worked at the European Commission Citizenship Europe of the Education and Culture DG and at the Education, Audiovisual and Culture Executive Agency. So very international, cross-disciplinary, Brussels-centered background. Third person to talk to you, Cornelia Kutterer, who I have the privilege to know for many years now. Cornelia is responsible for AI, privacy, and regulatory policies in the EU for Microsoft, with a focus on digital transformation and its ethical implications. She leads a team working on corporate and regulatory affairs, including competition, telecom, and content policies, and has been working or I had the privilege, as I said, to learn from her in very many distinctive legal fields and domains, because she has a very long experience in information society and internet policies on a truly European level. So whenever I don't understand what's really going on in Brussels, she's one of the key persons I hope to get some orientation from. And last not least, Sofia Ranchordas, who is a professor of public law and a Rosalind Franklin Fellow at the Faculty of Law of the University of Groningen in the Netherlands. She's working on digital platforms, in particular big tech companies, and how they are reshaping citizen participation, the design of smart cities, and how technology is changing the constitutional and legal protection enjoyed by citizens. This is also one of the reasons why Sofia kindly took over the task to talk to us today about one of the key instruments of the new regulation, which is regulatory sandboxes. She has been doing interdisciplinary and comparative legal research on regulation and technologies, smart cities, and the digital government, and is mainly focused on the moment on two central topics. First, digital inclusion and exclusion, and second, sandboxes is the key word here, regulatory innovation. Very much looking forward to have all of you here. I don't want to take too much of our talking time. Oscar, please jump into the field and help us in our first assessment of what's going on. Thank you.
Yeah, thank you, Nikolaus, very much for this very, very kind introduction. And yeah, what I'm going to try to do in the next couple of minutes is just talk about a couple of points that struck me when reading the draft regulation. Of course, this is a regulation that has been in the works for many years, and I think you can also see this, but maybe it's a habit of being trained in European law. Usually what I do when I look at these kind of regulatory regimes, I look at the legal background and specifically the provisions that enable the Commission to do this from a constitutional perspective. And in the case of the proposed AI regulation, that is, of course, Article 16 of the TFU of the Treaty of the Functioning of the European Union, which is not surprising because this is the provision that essentially relates to privacy and data protection. And of course, this is the field in which, especially in the European Union, a lot of these discussions have been framed. But the important point here, and this is what I would like to very strongly emphasize from the start, is that there is also another provision involved, and that is Article 114. And this is quite a complex and abstract provision when you look at it from the start, because it has a lot to do with the harmonization of the legal requirements of the internal market. But I think it's very important to point that out because, and I think you, at least I had the impression you felt this a little bit from the kind of reaction the presentation of the draft got from society in general, and especially civil society. The main focus of this proposal is not on the civil society issues, I would argue. It's really about the standardization of the technology and about the standardization of the internal market. And I think that very strongly resonates when you go through the proposal, but we can, of course, discuss that. Then another question and another aspect that I find very important is that given this strong association with the European privacy debate, and especially with the General Data Protection Regulation with GDPR, one of the key features of that type of privacy regulation is that it's technology neutral and principle-based, et cetera, But of course, as many probably also of our viewers today know, that has to do with the long tradition that privacy regulation has in Europe. The first laws go back to the 1970s. So we have like 50 years for the development iterative of rights and provisions, and it has been reframed. And so one of the big questions, at least for me, was when this proposal was being presented, which kind of route will the Commission take? Will it really stick to these like technology and principle-based regulation, or will it rather go for the opposite option, which is the really strong sector and technology focused? And I think it did a little bit of both in the end. So we know that the Commission always really very strongly emphasized this risk-based approach, so where it looks at the all kind of triangles that have been appearing throughout the presentation of the regulation, you know, where it says on top, so these are like applications where there is an unacceptable risk associated with it, and then there is like a very high risk associated with it, and there are transparency duties when you go high risk, and then the lowest risk is really this minimal or no risk, right? And when we look at the very, very top of the pyramid, the unacceptable risk, and the very bottom, the minimal risk, then I think you can argue that there is sort of like this principle-based approach, at least the attempt to do that, right? And in the middle, it's really a sector-specific approach where we're talking about specific kind of applications. So that I also find quite interesting. And then I would like to say something about this unacceptable risk and what the Commission did there. So the central provision there in the current proposal is Article 5. And I think we will have a lot of discussion going forward about Article 5 because there are essentially 4 paragraphs. And the first 2 seem to outline, like in a very general way, what would be the case, and then why it's not allowed, why it's unacceptable. And I just read out this Article 5, paragraph 1, letter A, which includes the first option, which is like about subliminal techniques beyond the person consciousness. So AI is used in that kind of way to cause another person's physical or psychological harm. And I thought about this provision now for a couple of weeks. I have to say, for me, it's really vague. I don't know what the Commission tries to do here. And also the second with also the same thing with the second kind of provision, which tries to address the risks of groups. But my concern here is the way that it stands, that it's too abstract to actually apply. So what is this trying to do? Who is actually the target? And the same kind of, concern, I cannot really say it's a criticism because this is just a proposal, obviously, but the same kind of concern continues when we go forward to this provision that has also been heavily emphasized by Commissioner Vestager, which is about social scoring. And of course, that there's going to be no social scoring within the European Union. And that is also, I think, relatively broad. Because when we look, for example, to China or places all over the world, social scoring system in their essence, I would argue, are financial or credit worth ratings, right? So credit scoring is really the issue here. And when you look then at credit scoring specifically, that is a high risk application, which is heavily regulated, certainly by the draft regulation, but still it's allowed. So I think the real question is not whether we call this credit scoring or social scoring. The real question here is which kind of data can be combined in the end, because credit scoring is allowed, to then in the end eventually have something like social scoring. Whether we would call that or not, then because we must not, because the Commission tells us not to, I think that's not so much the relevant question. And then of course the one provision that got most attention, I think, by civil society so far now, and I also read that the European Data Protection Supervisor, who will look closer into the draft AI regulation, will talk about this. And that is this real-time biometric identification, where there are 3 exemptions. I mean, I'm not going to go into them into detail, but the point I'm just want to make is that I think with these kind of exceptions, what will happen, and I think this is also the concern that civil society has now, is that all of these infrastructures are going to be built. And then in the end, we have to talk about, what are the exceptions? How does the overview look like? So we'll have like another kind of surveillance discussion. And I think we really need to probably have like a more fundamental discussion where we're really talking about, to which extent do we really want to have this very heavily digitized open public space? So can we have both? Can we have like all of those technological systems in place and then still have like public spaces that we appreciate? Or are we actually fine with those public spaces being permanently monitored by algorithms all the time? And then I think there is a deeper question underneath that, which is, so if there is a lot of data which is permanently monitored, but only by algorithms, so only by a system and not by a human, is that already an infringement of a right, or are we fine with that, right? Because I feel that is sort of really the underlying question when we look at these kind of technologies. So I'm certain there will be a lot of discussion about this specific provision from the political side. Of course, there's also from the civil society side still this Reclaim Your Face campaign. I don't want to make this too long. There's just 2 more things that I would like to share. So the first one is that when reading the proposal, as I said, for me, it's mostly a standardization effort. Most of this is about those high level risk AI applications that also, which are outlined in an annex, separate or attached, so to speak, to the draft regulation. The annexes give the European Commission a lot of power because essentially they are shaped through comitology. So that means that there is not directly an involvement of the European Parliament. It's maybe something to keep in mind. And then in the end, I would say, like as an overall assessment on the substantive side, I think it's a very well thought through proposal. So you really see that there was a lot of consideration, taking all of those ethical committees, etc., into account. But where I'm a bit concerned is when it comes to the enforcement side. And I think this is something that you see coming back again and again. So on these debates, there is a lot of consideration of the substantive issues, but when it then comes really to the enforcement, I think we really have to, but this may be speaking more as a European citizen, we really have to consider very carefully whether whether the autonomy of member states really works in these kind of settings that we have here, because the proposal has a system where each member state has like competent authorities, which, you know, do sort of like the technical standardization side of things. And then we have like a supervisory authority or more supervisory authorities per member state. And all of this comes together in this EU AI board, where the European Data Protection Supervisor has a role and where the Commission also has a role. But the point here is that there are so many different kind of layers which all have to work together in good faith for this to work. And I think here maybe we really need to very carefully reconsider when especially looking at the General Data Protection Regulation and all the good faith that is required from all national data protection authorities to work together on this, whether this really always leads to consistent results. And I would argue probably not. So thank you.
Thank you so much, Oscar. If I may, I ask spontaneously 2 or 3 questions immediately. So the very first one would be a very fundamental one. When you're talking about Article 5, so the prohibition of certain AI systems, your arguments that I understood was first that the one on the subliminal technologies is too vague, and second, the one which is about the law enforcement side is not tackling the issue in how far we fundamentally should prohibit something like this in Europe. That was, in my reading, mainly a typical academic assessment of the thing. But the important question, in my view, would be to an academic: do you think that this is, and this is what I would like to ask, do you think that this is something where you can formulate some criticism, just like you are doing it at the moment? Or do you consider it in the wording as it stands at the moment to be illegal? Because it's not, it infringes either the rule of law in the first case, or second, it infringes fundamental rights, such as in particular Article 8. So is this just a nice to have to change this in your view? Or is there a legal obligation to change this?
So when it comes to the biometric lives, what does it say? Biometric identification systems, real-time remote, right? Then I think we really need to have the fundamental discussion whether we want to have this in the first place. Because when you look at the data retention debate that is now going for 2 decades, right? We still don't have like a fundamental answer to this question whether we want to have those systems in the first place. And then what it often means in practice is that the systems are being introduced, and then we have all of this discussion about what are effective oversight mechanisms and how is it going to work. So I think there is really, in the end, going to be a dynamic very strongly from the law enforcement community to have those systems. And when you have those systems, there's no longer any space for the discussion whether this is an infringement in the first place. So I think there needs to be like a really clear categorical decision. My criticism on the first 2 points on this like subliminal technology, etc., is that I don't see how a court should really interpret it, because this is like a very, on the one hand, this is a provision which seems to prohibit so much, but on the other hand, it's really, really difficult to interpret. So that puts a court always in a position where you then really have to make, in a sense, a very strong political statement, right? Because the application, how you concretely then apply it to a case, that is always up to you. The law does not really give you clear enough, and that would be my criticism, and that's why it's at this point, because now we can still debate this, the law is not clear enough what it actually tries to do and for which kind of situations. That is what I would say.
Yeah, but when you say clear enough, you mean politically not clear enough. You don't argue that it's legally not clear enough, because that would make your argument a lot stronger, obviously. So if your standpoint were, we can't accept this because it infringes one of the fundamental rules of European fundamental issues of law and how to regulate things by laws, because it's not clear enough in the sense that the rule of law is broken, that would be a very different argument then, in my reading at least. Would you agree?
No, it's, for me, it's really about the clarity of provision. It's not really clear for me what it wants to do, you know. And then there is the question, is it clear on a political level what it's intended to do, and then the wording is just not wrong, so, or the wording is just not obvious enough, or maybe I don't understand it enough. But my worry would be the way that it stands, that it's essentially, it's like a very positivist argument, of course. The way that it stands, it's so hard to interpret that it will just cause problems in interpretation, because people will argue, so this is exactly what the rule wants to do, but then the court has to look at it, and it's not, it's very vague. It could be in there, but maybe also not, because it's not, the cases are not clear enough. So a little bit less of abstraction, so to speak, would be preferable in that sense.
I see. Okay, thank you, Oscar. Shall we continue perhaps with Gloria as the next speaker? Thank you.
Hello, and thank you very much for the invitation. It's a pleasure to be here, and it's a pleasure to follow such a clear presentation. I will probably say things more or less, some things in the same sense, but I do disagree with the general feeling or assessment. I'm less optimistic. I'm less convinced in general. So Oscar, I think you pointed some problems, and then you say, well, nevertheless, it's fine. I think there are major problems. So nevertheless, you cannot say it's fine. My main entry point here is really the policy ambition of this proposal. I think it's important to remind us that it's one of the many measures that the European institutions are taking in relation to AI. We have embraced this idea that we want more AI in Europe, so there is money being invested in this. There are many actions, and one of them was this promise of something that would deliver this trustworthy AI, the ecosystem of trust. So we are giving money, we are putting a lot of faith in AI, but in exchange or on the condition that at the same time we can trust AI. And this is what this is supposed to deliver. And I think it doesn't. And that's the problem. So if it was fine to have another regulation to support innovation through sandboxes, then okay, why not? If at some point we will get the regulation that telling us that we can trust AI. And this is the major problem. So I agree that indeed it is a strange regulation. You could say it's a safety regulation type, a standardization kind of thing. It's not what we expected. Some people expected this embracing of the ethical framework. I'm very happy that we are not going in that direction, that we don't start regulating on ethical principles that were very, very vague. And we take seriously, it's about the regulation, we need some rules, and that's fine, but at the same time, it's not about, so there are many references to fundamental rights. All this AI has an implication for fundamental rights, but we don't take the path of saying, well, let's strengthen individual rights. No, that's also something that this is really not about this. So what is this about? I think it's mainly regulation through documentation, regulations through procedures, through a big database. Let's write it all down. Let's make sure you have calculated the discriminatory potential here, write it down, put it in the database, and then let's go ahead. And there are many things that are missing. And this, I think, especially the role of the individual, not the user as the one who's going to use the systems, but the individuals who are affected by this and the groups who are affected by this. This is really not in the picture, and I think it is a problem for a regulation that it's supposed to give us trust in a system. Generally, I was with the white paper not convinced with the idea of the risk approach. I think now it's even too late to complain. I think it's a choice because we call everything AI. We cannot regulate everything. So of course, if we take this broad definition of AI, at some point we have to define what are we going to regulate seriously. The high risk AI, okay, that it's fine. But then indeed we have to be very careful about which categories are we creating. I think for coming back to this question of is the systems are the systems that are prohibited clear enough? I think for me the main problem is that indeed we are saying this and this is prohibited for this regulation, and it seems to imply that everything else is permitted, and it's not true. There are many uses of AI that are not permitted because they are already not permitted. They're not waiting for a regulation to just say that it's not permitted to kill people using AI. That's already prohibited, but then you have these AI prohibited systems by the regulation. And then what is very, very tricky is that if you have another provision referring to another use of AI, then it seems that this is clearly not prohibited. And there we have some cases, some mentions there that are for me extremely problematic. One is the emotion recognition. It is not prohibited. There is a reference regulating this. Therefore, it is possible to have this even more delicate and then more difficult to understand how can the European Commission endorse this, the automated attribution of sexual orientation. So there's AI just deciding what is the sexual orientation of people, that it's fine. It doesn't say it's always permitted, but it doesn't say it's prohibited. It says, well, if you do this, you have to inform the individuals that you are attributing to them sexual orientation in an automated way. And just to inform people, this exists. So there are people working on this. I was already like 4 or 5 years ago at a conference in the United States where actually they were presenting this subliminal use of images to detect sexual orientation of people. And I thought, really? And actually the people presenting this were presenting an ethical way of doing this, and they received a prize. And I really thought, come on, can we seriously accept this? And apparently, yes, we can accept this in Europe. It is fine to use AI to detect people's sexual orientation, and the European Commission is endorsing this. And you can even get your Thierry Breton certificate on this. So this is, I think, indeed a problem. Coming back to the remote biometric identification, I think indeed the issue is that we are not having a debate. It is very much like the data retention discussion Oscar was mentioning. So basically, this is the approach of the Commission, where they say we take a step forward for regulating something, but at the same time we have this provision saying member states can take many steps backwards and do whatever they want. We have this with the e-privacy directive saying, yes, we have e-privacy in Europe, but if member states want, they can still have exceptions. We have this in the GDPR, and not many people are aware of this or following this discussion, which is really problematic in itself. But we have Article 23 of the GDPR. So the GDPR gives strong data subject rights to individuals, but then there is a provision saying member states can, if they apply some safeguards, actually just obliterate those data subject rights. And they are doing this. And who is stopping them from doing this? Nobody, not the Commission, not the DPAs, nobody. This is happening now. For instance, in relation to AI, France has decided that we can have systems of AI automating, counting in an automated way how many people wear masks. And in relation to this use of AI, they have used Article 23 of the GDPR to just obliterate, delete, and annul the possibility to use your GDPR rights, which is really, really, for me, a problematic thing. So the European Commission is just opening the door for this series of steps back in the protection of individual rights. There are a few points more that I want to just mention before indeed hearing from the others. I'm very happy that Sofia will cover the sandboxes, because the sandboxes, again, I really don't understand how this specific regulation of sandboxes here contributes to trustworthy AI. It is about saying, yes, we are kind of reassured in general, but for the sandboxes, you can do whatever you want as long as you don't kill anybody or something like this. Then it is fine, especially if you're a startup, then it's even better. If we don't know who you are, come in and experiment with AI. And this is going to be good. I really don't know how this contributes to trust, but I'm happy that somebody will explain. And perhaps before I finish my overview, just I wanted to mention something that I think it's not very often mentioned, but I think it is very, very important objectively. And it shows that there are really some black holes in this proposal, that we have to be aware of this. And this refers to Annex 9. I don't know how many people made it to Annex 9. Oscar, Cornelia, did you make it to Annex 9? It's the last one, but it's huge. It's about the rights of millions of people. And it is about saying that EU-LISA, the agency of the European Union, will not have to comply with this regulation. So we had a tradition here in Brussels where we adopt a regulation imposing some rules on everybody, and then we give just bonus extra points, no need to comply to somebody. And traditionally it has been to Europol, like Europol doesn't have to comply with all the rules that we have in data protection law, we give them their own special rules. And here, for no particular reason at all, we have a framework for trustworthy AI for everybody, except for the EU agency, which is managing the largest databases in the European Union, applying AI to just evaluate who can travel to the European Union, who can stay in the European Union, who is going to be deported to another place. All this is exempted for this regulation. Why? I don't know. It is not explained, because at the same time, this regulation is saying it is very important that we have special protection in the area of migration, border management, asylum. All these people are very vulnerable. It's very delicate to use AI there. But then for EU LISA, why? Because the European level, because they are our friends, whatever, this will not apply. I think it shows that we really have to be careful with this proposal. If it goes like this, there are major risks for everybody's rights, also with the use of AI. So I'm very happy that there are discussions, and I hope that at some point some changes at least will be incorporated.
Yeah, Gloria, if I may repeat the same question that I asked Oscar, in particular on the last point, right? When you're talking about Annex 9, is your argument here, or would you agree in the sense that if Annex 9 comes into law as it is at the moment, so let's assume that no changes are happening, would that, in your assessment, be a breach of European law as it stands? So is it illegal to introduce this, or is it just a political question whether it's appropriate or not?
I think indeed that in the end we will have AI systems being used in a way that is not compatible with the Charter of Fundamental Rights. And it's not only because of this proposal, it is also because at the same time EU LISA has also some internal rules that have also deleted or just annulled all data subject rights under data protection. So they are not governed by the GDPR, they are governed by their own regulation. But also there they said, whenever we process data, in some cases, we will not comply with data subject rights requests. They are carving many exceptions, many possibilities that then indeed the end result might be that they are not doing things in line with the Charter of Fundamental Rights. So is a breach of the rule of law, this Annex 9 itself, if that's your question, it's not like as simple as that, but indeed we are not putting in place the safeguards necessary to make sure that all the important things that we are doing in this area of automated processing of data of third country nationals is compatible with fundamental rights. Okay, so then that's a very strong standpoint in a way, right? That you're making here. Yeah. I see. Okay. Thank you so much, Gloria. Now, Cornelia, I think you will help us in getting things a little bit more practical now, because I would assume that a company needing to deal with this and to prepare the business on this is probably even more struggling than just academics who already have a lot of issues. So perhaps you would like, Cornelia, to give us an overview about how Microsoft is dealing with the issue and how you as a person are dealing with all this which is coming here and all this which has already happened.
Well, I can try, but it's going to be hard.
Yeah.
So first of all, Nicholas, thank you very much for the invitation. It was also really great to already listen to Oscar and Gloria in their assessment. And since the adoption of the regulation, there is a lot of discussions ongoing. The Commission is obviously very engaged in explaining their views on this. So I have the feeling we are in this space of like learning each day a little bit more about the regulation, the meaning, and also with every single conversation, you get new aspects that you haven't thought about. So I appreciate being here and learning myself hugely. So we have been engaged in this discussion really early on and have also led some of the more prominent discussions, such as the facial recognition technology discussions at the very early stage when Brad Smith really was one of the first people to say we need to regulate facial recognition technology uses, in particular in such in where it becomes a threat to fundamental rights. And that was over 3 years ago, and I recall that we have been receiving a lot of questions, but we have GDPR, and this is eventually my first point that I would like to make. The AI regulation, it seems to me, and Oscar alluded to that a little bit already, is not focused to inform one specific fundamental right, such as GDPR does, which focuses on data protection and the data subject's right. But it's horizontal. And as Gloria mentioned, in principle, those rights exist whether the AI regulation is here or not. So in a way, as I would see it, it provides precisely the needed guidance and data and governance aspects to actually make a shift in how technology interacts with humans. So what I'm trying to say here is that when you try to implement responsible AI, there is a culture shift that is required across the whole organization, because you have to think very, very differently about how you're developing technology. So at the very beginning, when you start with developing a system, you really have to ask yourself, so why are you doing it? Whom does it serve? Who might be impacted? And you have a very holistic view about potential value tensions that could occur with the intended use. And that provides huge opportunities and is at the same time much more difficult to grasp than more static regulations such as the GDPR, where you have eye on the balls, the data subject right, and this is sort of where your guidance is. In a system or in a world where you have to think about, well, it could serve that part of the population, but it might impact another part of the population. It's going to be much more complicated. So I think that these socio-technical and culture shift issues, in my mind, could even be more underlined in the governance structure. But we do believe that the approach that the Commission has taken, so first of all, start with high-risk applications, also to learn how it functions, and then focus on having structures in place so that you can actually address certain risks. Because the mitigation of the risks are depending on the context. It's all contextual. That's eventually also one of the more problematic issues in the requirements for providers, because it's very hard. First of all, it's very hard to imagine all intended uses. You might have some intended uses in mind, but often an AI provider would have, well, first of all, you have AI systems that are foundational. Then you have AI components. You have pre-developed AI systems, and you have those that will be accustomed depending on the use that the customer will make. But again, no AI system provider will be able to imagine gazillions of potential uses that the AI system could be used for. So it's a little bit more complex and nuanced when you think about what type of AI systems you have. Then, of course, in the development cycle of an AI system, you start very early on to think about mitigation systems. Those can be processes, it can be documentation, it can be design choices that you make. By the way, with all the steps in such a process, there can also be errors. So when you think, for example, the error-free data sets, this type of data quality thinking might be very useful for one system, for example, facial recognition technology, but might not do the trick, for example, for other systems such as language systems, which are extremely complex. They're not regulated here, but there's also a lot of work going on in the research that is focused on responsible AI. That's eventually another part that, well, first of all, we appreciate that the Commission acknowledged, well, we don't really have standards yet. So the standardization process is at a very early stage. And the Commission allows sort of to comply with the regulation through state-of-the-art research, and there is a lot ongoing when it comes to the research of cross-disciplinary functions to try to implement Gloria, forgive me, I'll say ethical AI, but really the principles about being fair, private, accurate, secure, etc. You can also call them rule of law, I think, and in particular in the European regulatory landscape, I would be absolutely fine to work with rule of law. And then one other aspect that we see in the implementation process is that you make trade-offs in those systems. So you, for one system, like an 88% of accuracy is good enough for the result that you would like to achieve. In other cases, it would not be enough. And then you have to go into the detail. What does this actually mean, the 88% accuracy? When you break it down, it might be that, well, in one part you only have 74% of accuracy, and that might make it very difficult in that specific space. It might be very unfair for a certain population, for example. Or to give you another example, you might have a very accurate system that reflects exactly the data that is there. Think about a loan system where then the result is that women in general would get less loans because the system predicts that based on data that women, for example, earn less, which is truth, but you would like to obviously adjust your system in a way that is not the case. So you need to also think that there's choices in the intention of how you use it. So it's all of that is complicated and abstract, and that is what I think the regulation currently with the requirements on the providers is not reflecting enough. So these value tensions, trade-offs that are made in the collection of the data, in the design choices, in the risk management, and the rollout of those systems. These are just a couple of the more practical issues and more legal perspective eventually. And so when you think about this, we are currently like analyzing all of these issues, trying to take scenarios that are already existing and run them against our own responsible AI standard that we have developed, and of course now with the regulation and seeing where it works and where it doesn't work. I will stop here. I have a couple of things to say about the subliminal and the facial recognition, but I maybe wait for a second round.
Yeah, thank you, Cornelia. May I just drill this down again a little bit, if I may? I have two very simple questions. The first one is, you working as a lawyer in a global company that is developing such systems, do you have the feeling that if this text as it stands at the moment were the final text, that this regulation would help you in steering the development in your company, what is or is not supposed to happen? So is this something which gives sufficient guidance that it would help you in doing your job? And the second question, which is close to this one, I mean, one of the key arguments of the Commission is that we need this because it would also help us in developing European industry and to make Europe more competitive. And they are investing a lot of research money, and you know all this part of the game. Would you agree that this proposal, if it were the law, would or would not help Europe in becoming more competitive in developing such systems that are ethically and legally compliant? Or would you not buy that argument because such a company like yours would simply decide not to take the hassle with all these European regulatory difficulties and 5 academics trying to understand already the most fundamental rule in there, and simply go somewhere where it's much easier to do these things?
The latter will not happen. We seek to build our technologies in the spirit and the values of the European Union, and we are rolling basically our sleeves up and see how we can now work with the stakeholders to make it workable in practice. So what we do agree is the vision that the Commission has expressed in this proposal to achieve trustworthy AI. I think there are, as Gloria and Oscar alluded to, numerous areas where there has to be a social debate whether the Commission has made the right choices and the right delineations. It's not for me to say whether it's right. I can eventually, when it comes to facial recognition technology, give you a personal opinion about that. In this space, I think there were interesting debates over the last couple of years, and I think one of the most interesting cases that we have seen is the one South Wales court case, where I think the judges have done a fundamentally stellar job in assessing precisely what Gloria was talking about, the human rights assessment against the use of real-time remote biometric identification. And when you read through these, whether irrespective of the result of that specific decision, I think the components in the decision are now reflected also in the proposal for this AI regulation. Now, the choices that have to be made is precisely as Oscar said. Do we think that for finding missing children or for a imminent terrorist attack or for any of the many serious crimes that are listed in the third part of the exemptions, we agree that it's proportionate and necessary. And this is just where I think everybody will have personal views, and at the end of the day, it's probably one of these cases where we will at the end have to wait for a human rights judgment to make that decision. Now it's in the hands of the policymakers. Now back to your question on the specifics as it is now drafted. This goes back a little bit to some of the points that I raised, where I think the proposal will have to be adapted to a more practical way of how these systems are developed. I think it's hard to answer this question with a yes and no. I will hope so that policymakers will now take the time to really understand how AI is developed and what type of choices we need to make, and really not only the engineers have to do this culture shift, we all have to, to a certain extent, do this culture shift and thinking differently about the choices that we make at a very early stage in the process of such a development.
Okay, thank you. Thank you. I must confess it's more or less the answer that I would have expected. Yeah, indeed. Thank you. Thank you for this. Yeah, so then let's try to have a closer look, Sofia, if you agree, into one of the more innovative approaches that are to be seen in this draft. Would you kindly explain to us what the regulatory sandbox is and what it would help for in this case? Thank you.
Thank you. Thank you so much, Nicholas, for the invitation. So regulatory sandboxes are presented in Title 5 of the AI regulation proposal as a measure to support innovation. And it's not the first time that regulatory sandboxes have emerged in this context. Also in the EU Coordinated AI Plan, it was already mentioned that it was important to experiment with new regulations. Also the conclusions of the Council last year pointed out exactly in the same direction. So experiments, regulatory sandboxes, anything that actually conveys the idea of forward-looking, future-proof regulation was actually regarded as being something positive for the development of AI. What is interesting is that regulatory sandboxes and experiments are fairly recent in the area of AI, but they are actually not as recent as one would think in general, say. So basically, I would like to make 2 points in my brief presentation. First, I would like to explain what they are, how they are presented, and what it's not said yet in the proposal. And then secondly, talk a little bit about the legal problems, because experimental regulations have been used actually for even centuries. So we have actually a lot of experience in many countries in Europe, like France. Germany as well has experimented for a long time. The UK, of course. So we do have this experience, but it seems like this experience is not really being used here in the regulation to actually present a better framework, a better legal framework. So I think it's important to reflect upon the legal problems. So the first point on the AI sandboxes. So basically in Title V, as Gloria already mentioned, there is, we come across these instruments that allows small companies to experiment with new AI products. So it's not that everything will be allowed, of course. So you cannot, deviate from, data protection regulations. You cannot put at stake health or safety risks. So there is still this risk-based approach, which is very, very dominant here. It is important to be said that regulatory sandboxes can offer different types of environments. So a regulatory sandbox is basically a test environment where you basically select a few companies, a few firms, to experiment in a certain area. So for example, the regulator would say, in this case, I would like to test new AI applications in the area of healthcare. So companies can then apply and then bring their projects. There will be a selection. And then within a certain period, let's say 2 years, it's the average, like 1 to 2 years, the average duration of a sandbox at national level. Then basically the company will be guided by the regulator in the implementation and design of this new technology. That's basically how it works at national level. At the European level, we actually don't have a lot of information on how this would take place, but the idea would be that national authorities would develop then sandboxes along probably the lines that we already know for other sandboxes. So sandboxes have been used since 2014, 2015 in the UK to promote the fintech. And since then, they have expanded throughout the world. We see them in many countries, I would say mostly Commonwealth countries. And they have been used also outside fintech to also test new products and services in healthcare, for example, energy and telecommunications. With AI, basically what you do is that you copy the model that is being used now in other regulated sectors by saying, look, we know that we have a very strict regulation, very risk-based, and this could potentially be an impediment to innovation. We don't want to do that. So we create a room for experimentation for companies still to play a little bit with new models, because if we just block everything that could be high risk, we don't know what can still come out. I think this approach of having like innovation-friendly rules is in itself a good idea in theory, I would say. And I personally, I wrote my PhD on this topic many years ago. So in that sense, it is something that I have been advocating for the last years. But the problem is that when one actually comes up with these regulatory sandboxes, it's very important to provide a lot of legal certainty on the exact fields where this will be possible, because a regulatory sandbox can consist in the adoption of different types of waivers, guidance, and regulatory comforts. So in a sandbox, you can say, well, companies can set aside certain regulations. That is possible as a waiver. But what you can do in a regulatory sandbox, which I'm not sure the proposal actually has thought of, is not actually just derogate regulations, but actually to just provide guidance regarding certain kinds of enforcement, provide bespoke guidance, basically. And that is something that is used in certain regulatory sandboxes. We don't know exactly whether this will be possible. And then, of course, you have systems of regulatory comfort or shared risk, where basically the innovator tries a new product, but it is concerned with the breach of rules. And then they can actually say, well, for this period, we're not going to enforce the rules, and then see what happens. And then basically there's an agreement between the two parties that there will be a period without enforcement as long as there are no major risks. So we don't know exactly how these regulatory sandboxes will take place. And I think this is a missed opportunity, because one of the key issues, and I would like to then go to my second point, is that regulatory sandbox in itself, just like other experimental regulations, can be innovation friendly and can be very positive to advance innovation. But the only way they can do that is when we actually have a methodology to actually experiment. Just like in social sciences, if we don't know how to experiment, if we don't have a methodology, anything that comes out of it will not be, cannot be taken seriously, because the sample of a sandbox is usually just too small. The cohorts of regulatory sandboxes at national level, for example, in fintech, is sometimes like 15 companies, 15 startups, or 10 or 20, but it's usually very small. It doesn't last very long. So the question is, as a scientist, I think you have to ask yourself, how generalizable is this evidence? There were no risks, there was no harm, caused in this, cohorts. But what happens when we open this to the big markets? Can we generalize the evidence? And that is the thing that probably we cannot. So this is a big shortcoming of a regulatory sandbox that I personally think that should be addressed. So that is one point, because the European Commission then delegates all further regulations to implemented acts, which is, in a way normal. But I think that more should come into this legal basis, because one of the biggest challenges that have been, detected in experimental regulations throughout, Europe, I would say, is that the principle of legality and the principle of legal certainty, they can very easily be shaken by an experiment. So we have seen in the case law of the German Constitutional Court, for example, that has accepted many experimental regulations, provided that they actually have a very clear legal basis, provided that they actually provide information to allow that there was legal certainty and they were proportionate. My question here is, we don't have this information. We don't know how national authorities will implement these regulatory sandboxes. And so this legal uncertainty will exist, this legal fragmentation will exist. So in that sense, what I'm concerned for the future, this will be my last remark, is how the coordination between the different member states will be actually defined to ensure that there won't be that much legal fragmentation and differences in the design of regulatory sandboxes, because according to the proposal, basically it's up to the national authorities to actually define much of it. And secondly, I think it's important to actually ensure that not everything is allowed in regulatory sandboxes. So we actually need to have more safeguards than only major risks to health and safety. We need to have more safeguards. We need to have more limitations. And possibly we also need to ensure that there are a bit more limits to what can be done and how they are evaluated, because the methodology of a sandbox will determine its value, also not only to innovation, but also in general to achieving actually standardization of AI in the internal market. So in that sense, I think for the Commission, there's still some room for improvements because this proposal still defines, puts a good instrument. I would say that experimental regulations are a good instrument in itself, in theory, but they are only as good as their methodology. And I think there hasn't been much thought being given to this point in specific.
Thank you so much, Sofia. Gloria has a question to you directly.
Yes, I do. And just in the meantime, so I'm glad to hear that you have concerns, because I also had many questions and concerns. I would not be so concerned with the fragmentation problem. I think they will link this with the common data spaces that they are building. So they have a common data space with common sandbox or something. My question is, how do you see the relation between those sandboxes and just experimentation that has been going on already for many years in the context of EU-funded research? Because there has been a lot of experimentation, a lot of things that have been happening. For me, it's the same kind of experiment. So you put between brackets the possible impact of your research, because when you have a research project which is funded by the European Union, you say, I only have to comply with data protection for what I'm doing for the experiment, but I don't care what will happen afterwards. And I think it's the same spirit of the sandbox. For me, it's a bit paradoxical that the European Commission is not learning from their own mistakes, because there has been a lot of loss of trust due to many projects that have been funded by the European Union, which were highly controversial. You know about the lie detectors. And instead of saying we reinforce the ethical, even I'm happy with having ethical frameworks there, anything to control this, we just create a new thing that it's more or less the same but even more Wild West? Is it? Do you see a relation between research already happening and the sandboxes?
Well, that's a good question. So it is true that with sponsored research, there has been a lot of experimentation going on. I mean, as a lawyer, I would say that that kind of experimentation that's been going on is actually a different kind of experimentation. It's more like kind of experiments that are done before something is really regulated on the market. So regulatory sandboxes are a step ahead. So I would say that, and that's what I'm missing here in this proposal. So there are different steps when in experimental method. So we can still have this, kind of experiments, sponsored by the European Commission and everything, and then we can have these derogations from regulatory frameworks at a wider level. But the thing is, we need to have like a process that connects all of it, because right now you're right. I mean, it would be helpful, for example, to if we have an experiment sponsored by a European project, then submit it again to a regulatory sandbox, compare it to other startups, compare it to other projects. This would be helpful, because then you would have a pool of things. And then when we don't have this, it's totally disconnected. And this, because if we would have this connection between experiments, this could actually be valuable. Also, the question is, for example, they could actually instead have opted for experimental clauses, which is totally different. It's not a sandbox. And this was actually mentioned in the EU coordinated AI approach. If you actually say, well, we're going to experiment with a certain disposition and say, well, we're going to really create an environment, a sample, and then with that sample of member states or sectors, we will really have a European-wide experiment to see with low risk, some certain low risk AI systems, whether something works. And that would work. That is not a regulatory sandbox. That's just an experimental regulation with very clear legal principles. And this could have been done. For example, I mean, the European Commission has done experiments like that in tax, for example. And this would have been a little bit like less Wild West, because the sample would be bigger, but at the same time, it would be more limited. And it would have a stronger regulatory framework. And there is more experience from the national member states side with this. The regulatory sandbox is a little bit something in the middle, hot topic, I would say. So, but I still feel that it will only work if we actually provide more legal certainty, because right now it's just too disconnected from the rest of the legal frameworks that exist.
So if I get your last point correctly, Sofia, you would argue that this is something which will not help in achieving one of the main goals of the whole regulatory attempt, which is foster European solutions and foster European ethically and legally compliant solutions.
Not in its current state. So I would say that if it is to advance trustworthiness of AI, and combine this trustworthiness of AI with innovation, which I think is a very important point, I think then we need to provide more information on how those regulatory sandboxes are going to be designed, more limits, because otherwise this needs or this goal to advance innovation will probably undermine the other goal, which is to promote trustworthiness in AI. So in that sense, I think we need to balance this, and this requires much more information, which should not be just adopted in delegated acts. It should be also adopted in the regulation, because when we have experimental legislation in member states, it's actually in the key statutes that we find a lot of information on, for example, what rules can be set aside, what rules cannot be set aside. So we don't delegate all of this to secondary legislation. We adopt much of it in this key legality base. So this is still not enough, I would say.
Which brings me to a question that I would probably like to ask all of you, which is, what would you think that is going to happen now? So what is your prognosis about the near future with this proposal? And what do you think that should happen now? So what would be your legal claim how to deal with this proposal at the moment? I don't know who wants to answer this. Perhaps you do it in the reverse order. So Sofia, what do you think that will happen, and what would you ask that should happen?
Well, I think that many of these positions will still be changed because there's quite a lot of criticism, and the risk assessment is still very vague. When it comes to regulatory sandboxes, which is the area I'm talking about, I think the Title V will have to be significantly changed. I would like to see more information on more limits on where it can be one can experiment with and what not. and also some more guidelines for the member states on experimentation limits. Because, as I said, I do think that the idea of experimental regulation is good in itself, but we don't have a right methodology for it. So I really hope the new future amendments to the regulation will actually include more thought on this.
And would you expect that this will happen?
I think I expect some of it to happen. Not everything, but
Who is going to bring this to Parliament? You think that the Parliament is going to do this? Because I don't think that the Council will bring more more regulations for the member states, right? So
no. So
it should be the Parliament.
Say that the Council will not bring it forward. I mean, also the Council conclusions from November last were very optimistic about experimental regulations. I think the European Parliament might have some doubts about it because experiments are still very controversial from a legal perspective. So I think that there are some states in Europe that experiment. The Netherlands is one of them. Germany as well. In Germany, there are quite a lot of number of regulatory sandboxes is growing. In France as well. But in France as well there has been a lot of criticism to experiments from a legal perspective. I think there are some member states who will raise doubts. There will definitely be some pushback from the parliaments. So perhaps there will be something, but I don't think regulatory sandboxes will go away, for example.
Thank you. Cornelia, what do you think?
So first of all, what I think is happening, or what I know is happening currently, let's put it that way. Of course, the Commission has put the regulation or the draft out for consultation. So most stakeholders, I would assume, as we do, are now assessing in a very in a fair amount of detail what that means for us and respectively civil society and others and users. In particular, we didn't talk about that. There is this interaction between high risk and product regulation that is already existing. So there will be those sectors that will have to look at this in more detail as well. So the consultation, which currently ends on the 5th of July, will be a very important period for the reflection and really putting forward what works and what doesn't work. I think this is a welcome step because it will probably help everybody to then define this a little bit more. The Council has already started with its first meeting with the Commission, so we assume that once the Slovenian presidency takes over from the Portuguese presidency, that they will start fairly early to run through the proposal. They have made this a priority under their presidency. So I would expect that this will be a very busy autumn for the AI regulation in the telecommunication working group, which will take the lead. In the Parliament, that interestingly, I would have expected a longer fight over who will lead the file. It seems, and this is a little bit surprising, however, that the Internal Market Committee will take the lead. There was, I think, more likeliness that it would be URI or ITRE, the industry. ITRE and IMCO have done a deal between AI and data files. I would expect the legal committee still to sort of raise their concerns about this. So this remains interesting for at least for Brussels bubble people, an interesting development. Currently on the observatory, at least, it is noted that it is the IMCO which leads with opinions from URI, ITRE, and the LIBE committee. And this is, of course, interesting because, as many of you probably also know, the Parliament has been extremely active over the last 2 years on artificial intelligence. I'm not entirely sure. There was between 7 and 8, 9 own initiative reports taking on numerous different aspects. So we already have a little bit of a sense of opinions. Of course, they're not binding and maybe also not very reflective when it comes to the real legislation, but the process is really kicked off now in the legislative process. Now, as I mentioned before, what I would like to see is that the policy decision or the decision makers really take their time on this, because it is really new. Also, the Commission has taken some really innovative steps here to address the novel kind of technology we are dealing with. And I would really like to stress this again, that the approaches to that technology are huge opportunities, but we cannot be too static in how we are dealing with it in order to keep the opportunities in really being more intentional about outcomes that we would like to see. So this is sort of for us, of course, the core areas that we will be active around. And how do you actually make this work in practice to achieve the policy goals that the Commission has put forward that we entirely support?
Thank you. Thank you so much. Gloria, what's your assessment?
I think an easy prediction that I could even bet some euros is that the role of the Commission will be modulated. We know from other proposals that the European Commission always foresees this protagonist role in relation to everything when they propose something, and eventually all other institutions say, well, maybe that's not for the Commission to do on its own. Here the Commission is deciding what is AI, they are deciding what is high risk, they are having the big database, they are doing it everything on their own, and I think this is something that will be discussed because people like to see things a bit differently, so that's the easy prediction. I think all the rest is more difficult to predict as such. I think there are some hopes that we can have. Indeed, we could hope that the European Parliament would do something positive. They sometimes do, not always. But I think the other big hope is that the Council of Europe will be active enough and vocal enough and just create here some envy, some jealousy from the European institutions, that they will see that the Council of Europe is doing things. And I think there was already some reaction because they did, there was some guidelines on facial recognition, also dealing with categorization. Here we have then categorization in the proposal. So this bit of competition between the Council of Europe and EU institutions could motivate some positive change. Other positive changes can sometimes happen if there's a big scandal, something going very, very wrong in Europe. Perhaps that's the solution. Yesterday or 2 days ago, there was a good, interesting judgment coming from Brazil about the possibility to have automated recognition of age, of gender in public spaces, in metro, just when you go in public transport. Is it possible to just classify people on the basis of the gender just like this? And the court said no, it's not possible. So are we really Europeans less protective than Brazil? Well, congratulations to us if that's the case. I think perhaps some of this motivation could be good. For me personally, what I would really like to happen if I was deciding on this is really to give some role to individuals. I think we cannot really trust that indeed the provider will think about everything and then the Commission will think about everything else, and at some point the individual has to understand something. Just to give the example of this database that is proposed. So there will be a big database of all the high risk AI systems certified in the European Union, but then we will be able to access this database, but we will never know if those systems are being applied to us. And how reassuring and trustworthy is this kind of work when you have a list, a database of all the high risk, very, very scary systems that are out there somewhere in Europe certified. And there's no way for me to actually knock at the door of my university and say, hey, are you using any of these high-risk systems? No, I will have no right to know who is using them. I will have no right to know anything about them. So I think we have to think about what can individuals do, what can we get from all this, in which moment individuals will be there. And perhaps the second wish, as I have, we were told that time was flexible, we have time for wishes. It's really a clarification of this definition of biometric categorization. It is a very, very strange definition. I think they are trying to regulate something, and then they put many words together. There's a sort of, they're trying to regulate categorizations, automated categorization of people, and then using biometrics, the definition of biometrics that comes from the GDPR, which is about unique identification. So use of facial recognition, of voice, of anything for unique identification. And then there will be some categorization based on this, and they are mixing everything in a single sentence. As I mentioned, sexual orientation, political orientation, age, gender, everything in the same sentence, and saying that it's sort of permissible, or we're not saying it's prohibited, and just make sure that people know about this, and everything will be all right. So that definition. I think people are not really focusing on that because they focus on the remote biometric identification, but that definition is very, very dangerous.
Thank you very much, Gloria. Cornelia has a remark.
Yes, thanks. Just because of a couple of things that Gloria was saying, where I think the regulation eventually lags a little bit behind the opportunities here in making this a little more citizen oriented. Is what was in the white paper. In the white paper, the Commission was still having this sectoral approach to a certain extent, which I think wasn't very coherent, but where it, in my mind, made from a citizen's perspective a lot of sense was the public sector. So it's interesting that a lot of the obligations fall on the provider, but it's really in the public sector where transparency is, I think, absolutely key. And so examples like, for example, the city of Amsterdam that has made this, that has now a transparency registry for the uses of AI that they deploy is, I think, one of the areas in how citizens potentially will be able to enforce their own rights that already exist in many other legislations. But this part of the transparency in the use in the public sector, I think, would be a critical part. So if I were in the civil society, that would probably my core demand to get in there. And it I think also addresses some of the issues that Gloria was raising. I was surprised by this heavy focus on the provider versus the deployer. I think many of the intended uses really will then be once the system is deployed. Just to give you a quick example, I don't want to over take the time now here, but if you have a technology where you can then improve the let's say in the education space, right? You want to improve the learnings individually for certain students. That can be a very good thing, but when you're using it to start excluding students because of prediction, that's very problematic. So it's this decision and this fine-tuning in how those uses are done, and you can only really address this when the deployer will make its intended uses, document its intended uses, and has its risk assessment when the system will be deployed in this specific context. And this is sort of where it looks at, as I look at it at the moment, but we are still like trying to understand. So with a little bit of a waiver, I think this is where we could achieve more if a bit more focus would be given on what happens actually when they are deployed. So.
Thank you so much, Cornelia. Gloria, would you like to reply immediately?
No, yes, I agree that this idea of transparency, it's very important. It is sometimes tricky to really have this demarcation, a useful demarcation between public sector and private sector. I was thinking about education now, so many private apps being used also in public schools, and then who has this obligation of transparency? It is complicated, but I think a way for citizens, for individuals to know what is being applied to them, it's necessary.
Mm-hmm. Thank you. Oscar.
Yes, thank you. And I was really very insightful. So thank you all. Really, I just want to start with, I really found the statement by Sofia was very inspiring and what she said, because in the end, I thought it linked to the point that I tried to make earlier at my earlier intervention, the last point, that there are too many levels involved on the national level and the European level where decisions can be made. And I think particularly this area of sandboxes is where it becomes visible, because it's a lot about culture and about cultural perception of risk, and how different, there's a lot of space actually, although it's the same substantive rules, but there's a lot of space to institutionally interpret them and implement them and then build ecosystems around it, right? So that is actually something that I would be a bit concerned about, because again, making the parallel to the general data protection regulation, we also see that different national data protection authorities have different approaches when it comes to, what they're prioritizing in terms of what they're investigating, how fast, which kind of fines they're imposing, etc. And I would really caution in that sense against going down the same route with this regulation. And then to your initial question, so what's going to be happening next? I think it's really still very difficult to understand all of these implications of these legal frameworks, because in a sense it's even broader than data protection regulation or environmental regulation. In German we have this wonderful word of the Querschnittsmaterie, so one area that really goes all across the landscape, right? And it feels exactly the same here. So that's what I would guess would be happening, that all of these sectors are starting to look now. And one of the sectors that I find particularly interesting is the security sector, because first of all, there is like a general blanket exemption, as also you pointed out, Nicolas, for the military sector, which I think you can even take as an indication as the genie is out of the bottle, right? There is no way, even if the Europeans are not regulating it, there is no way that that will not be happening, which is probably very concerning. But then, even more interestingly, I think from a institutional and analytical perspective, is the security sector. And I think Gloria pointed that out with the Annex 9. But for example, another interesting question to think about is, so what, as is happening in the Netherlands, what if you have a national police that is, for example, developing a predictive policing system, right? Which is also sort of AI, at least in the sense of the definition. Would that be covered, and to which extent by this regulation? Because obviously in the treaties, there is this exemption for national security, right? And so to which extent does this regime then really try, the proposed AI regulation, does this really try to rein in these sort of attempts? And I can also imagine that there's going to be a lot of friction in that sense. And then the last point that I'm making is that I can only echo what has been said before by Cornelia and by Gloria, that I think there is still this question, so what is really in it for me as a citizen, right? So why is it beneficial for me? And I think especially over the last 2 or 3 years, this whole array of technologies has been very much discussed in terms of potential harm that it does, and that it really affects people in a negative way, or that it limits the way that we can express ourselves in society. And I think that is really a key question here, especially I think for policymakers who are really supportive of the development of this, and for those who want to reap the economic benefit from it.
Thank you so much, Oscar. So I would like to end this slowly now by indicating again that there is going to be there is a consultation happening at the moment. So people are invited to write on their opinions in this literally now until I think the 9th of July. I'm very much looking forward to this debate. I do hope that we will have some input during this period, and I would really like to have a follow-up round of this after the consultation so that we can see whether some of the arguments you brightly made and so efficiently made in the last 90 minutes made it through the political arena then. Thank you to all of you. I really learned a lot. I think it was really worth the time. I appreciate your input, and I appreciate also that we have so many listeners listening to this. All the best to all of you. Have a wonderful weekend. Stay connected with us, stay interested, and in particular, stay as healthy as possible. All the best. Thank you. Bye-bye.
Bye-bye.